Good day, sir. I am Meriam B. de la Rosa, and this video will be my final examination video for the past CLJ400 Section D. Number 1. In Rule 128, Section 1, Evidence. Evidence is the means sanctioned by these rules of ascertaining in a judicial proceeding the truth respecting a matter of fact. In Section 2, Scope, the rules of evidence shall be the same in all courts and in all trials and hearings, except as otherwise provided by law or these rules. Number 2. In Rule 130, Section 1, Object as evidence are those addressed to the sense of the court when an object is relevant to the fact in issue. It may be exhibited to, examined, or viewed by the court. In Section 2, Documentary evidence. Documents as evidence consist of writings, recordings, photographs, or any materials containing letters, words, sounds, numbers, figures, symbols, or their equivalent or their modes of written expression offered as proof of the contents. Photographs includes still pictures, drawings, stored images, X-ray films, motion pictures, or videos. In Section 22, testimony confirmed to personal knowledge. Witness can testify only to those facts which he or she knows of his or her personal knowledge, that is, which are derived from his or her own perception. 3. Corroborative evidence is additional evidence of a different kind and character tending to prove the same point. It is a piece of evidence that may be derived from various sources but prove as a common point. Meanwhile, cumulative evidence is additional evidence of the same kind and character tending to prove the same point. This is purely the accumulation of similar evidences that is derived from common sources. Number 4. Prima facie evidence. Prima facie evidence is evidence which, if unexplained or uncontradicted, is sufficient to sustain a judgment in favor of the issue it supports. Otherwise said, it is opposing party does not offer an explanation and present contrary evidence, then the prima facie evidence will be enough basis for the court to rule in favor of the party that offers the prima facie evidences. 5. Section 37, Dying Declaration. The declaration of a dying person made under the consciousness of an impending death may be received in any case wherein his death is the subject of inquiry as evidence of the cause and surrounding circumstances of such death. Number 6. In Section 44, part of the res gestae, statements may be a prison while a startling occurrence is taking place or immediately prior or subsequent thereof, under the stress of excitement caused by the occurrence with respect to the circumstances thereof may be given in evidence as part of the res gestae. So also, statements accompanying an equivocal act material to the issue and giving it a legal significance may be received as part of the res gestae. Number 7. In Rule 132A, Section 4, Order in Examination of an Individual Witnesses. The order in which the individual witnesses may be examined is as follows. A. Direct examination by the proponent. B. Cross-examination by the opponent. C. Redirect examination by the proponent. And D. Recross-examination by the opponent. Section 5. Direct examination. Direct examination is the examination in chief of a witness by the party presenting him or her and the facts relevant to the issue. In Section 6. Cross-examination, its purpose and extent. Upon the termination of the direct examination, a witness may be cross-examined by the adverse party on any relevant matter with a sufficient fullness and freedom to test his or her accuracy and truthfulness and freedom from interest or bias or the reverse, and to elicit all important facts bearing upon the issue. In Section 7, redirect examination, its purpose and extent. After the cross-examination of the witness has been concluded, he or she may be re-examined by the party calling him or her to explain or supplement his or her answers given during the cross-examination. On redirect examination, questions on matters not dealt with during the cross-examination may be allowed by the court in its discretion. Section 8. Recross-examination. Upon the conclusion of the redirect examination, the adverse party may recross-examine the witness on matters stated in his or her direct examination and also on such other matters as may be allowed by the court in its discretion. In Section 9, recalling witness. After the examination of a witness by both sides has been concluded, the witness cannot be recalled without leave of the court. The court will grant with withhold leave in its discretion as the interests of justice may require. Number 8. Judicial Affidavit Rule or JAR took after on January 1, 2013. A normal court proceeding will take around 3 to 5 or even more years to be fully decided. By requiring the submission of written affidavits or witnesses through the JAR, the time for concluding a court proceeding will be shortened. The JAR seeks to decongest the ever-increasing caseload in the country, brought about by the high number of cases filed each day and the lengthy procedures observed. The JAR also seeks to address any lost translation in interpreting the testimony of a witness if the testimony was translated from a local language into English. Number 9. There are only 2 exceptions where compromise is not admissible as an implied admission of guilt in criminal cases. Number 1. In quasi-offenses or acts defined and penalized under Article 365 of the Revised Penal Code, reckless imprudence and simple imprudence of negligence. 2. Those allowed by law to compromise, their usual examples are found in the Revised Penal Code, particularly in Article 266b of the Revised Penal Code. The compromise that the victim agreed to marry and indeed got married to the accused in a rape case, or if a compromise was made before the filing of the criminal complaint.
Number 10.
Section 4. Evidence is relevant if it has a relation to the fact in issue as to induce belief in its existence or non-existence. From this rule, we gathered that there are 2 components of relevance. First, relevant evidence has a relation to the fact in issue. If there is a relationship between the evidence and the fact in issue, then the evidence is materials. Second, relevant evidence can lead us to believe in the existence or non-existence of the fact in issue. If the evidence supports our belief that the alleged fact exists, then the evidence has probative value. Number 11. In Section 10, leading and misleading questions. Questions which suggest to the witness the answers which the examining party desires is a leading question. It is not allowed except A. On cross-examinations. B. On preliminary matters. C. When the difficulty in getting direct and intelligible answers from a witness who is ignorant, a child of tender year, is of feeble mind, or a deaf mute. D. Of an unwilling or hostile witness, or E. Of a witness who is an adverse party or an officer, director, or managing agent of a public or private corporation, or of a partnership or association which is adverse part. Number 12. A misleading question is one which assumes as true a fact not yet testing true by the witness, or contrary to that which he or she has previously stated. It is not allowed. 19. In Section 4, circumstantial evidence when sufficient. Circumstantial evidence is sufficient for conviction if A. There is more than one circumstance. B. The facts from which the inference are derived are proofs. And C. The combination of all the circumstances in such as to produce a conviction beyond reasonable doubt. 14. In Rule 131, Section 1, burden of proof and burden of evidence. Burden of proof is the duty of a party to present evidence on the facts in issue necessary to establish his or her claim or defense by the amount of evidence required by law. Burden of proof never shifts. Burden of evidence is the duty of a party to present evidence sufficient to establish or rebut a fact in issue to establish prima facie case. Burden of evidence may shift from one party to the other in the course of the proceedings depending on the exigencies of the case.
Number 15.
In civil cases, the party having the burden of proof must establish his or her case by a preponderance of evidence. In determining where the preponderance or superior weight evidence when the issue involved lies, the court may consider all the facts and circumstances of the case, the witness' manner of testifying, their intelligence, the means and opportunity of knowing the facts to which they are testifying, the nature of the facts to which they testify, the probability or improbability of their testimony, their interest or want of interest, and also their personal credibility, so far as the same may legitimately appear upon the trial. The court may also consider the number of witnesses, though the preponderance is not necessary with the greater number. In criminal cases, Section 2, proof beyond reasonable doubt. In a criminal case, the accused is entitled to an acquittal unless his or her guilt is shown beyond reasonable doubt. Proof beyond reasonable doubt does not mean such as degree of proof, excluding the or polity of error, produce absolute certainty. Moral certainty only is required, or that degree of which produces conviction in an unprejudiced mind.
Number 16.
Substantial evidence. In cases filed before administrative or quasi-judicial bodies, a fact may be deemed established if it is supported by substantial evidence, or that amount of relevant evidence which a reasonable mind might accept as adequate to justify a conclusion. Substantial evidence is the least quantum of proof required by the rules. It is applicable in administrative action which, unlike judicial actions, do not include conducting full-blown trials and are meant to be concluded with greater speed. An administrative body can render a decision on the basis that the evidence presented is evidence which a reasonable and mind accept as adequate to justify a conclusion. This means that the evidence can make a reasonable person believe that the allegations have occurred. Number 17. Classes of documents. For the purpose of their presentation in evidence, documents are either public or private. A. The written official acts or record of the sovereign authority, official bodies, and tribunals and public officers, whether of the Philippines or of a foreign country. B. Documents acknowledged before a notary public, except last wills and testament. C. Documents that are considered public documents under treaties and conventions which are in force between the Philippines and the country of source. And D. Public records kept in the Philippines of private documents required by law to enter therein. 18. In Rule 132, Section 20, proof of private documents. Before any private document offered as authentic is received in evidence, its due execution and authenticity must be proved by any of the following means. A. By anyone who saw the document executed or written. B. By evidence of the genuineness of the signature or handwriting of the maker. Or C. By other evidence showing its due execution.
Authenticity.
Any other private document need only be identified as the which it is claimed to be. 19. Original document must be produced. Exceptions. When the subject of inquiry is the contents of the document, no evidence shall be admissible other than the original document itself, except in the following cases. A. When the original has been lost or destroyed or cannot be produced in court without bad faith on the part of the offerer. B. When the original is in the custody under the control of the party against whom the evidence is offered and the latter fails to produce it after reasonable notice. C. When the original consists of numerous accounts or other documents which cannot be examined in court without great loss of the time, and the fact sought to be established from them is only the general result of the whole. And D. When the original is a public record in the custody of a public officer or is recorded in a public office. Number 20. Qualification of witnesses. In Section 20, witness their qualification. Except as provided in the next succeeding section, all persons who can perceive and perceiving can make their own perception to other may be witnesses. Section 3. Extrajudicial confession not sufficient ground for conviction. An extrajudicial confession by an accused shall not be sufficient ground for conviction unless corroborated by evidence or corpus delicti.